My name is Akansha Gupta. I belong to Group N214 and we are 5 members in a group. We all together studied the segments of contract law as well as corporate law. So the first segment of the contract law is Mickey versus SSO Burgers. So the case was like that Mr. Mickey or Mr. Michael was a great fan of SSO Burgers, but SSO Burgers were not doing great sales. So in order to promote their sales, they started a promotion in their fair dunking deal that every of the EMU double-decker burger would have a token, and some of the tokens will be having a golden car coupon. So any customer who collects those 50 of those coupons would get a CX Mazda car. So being passionate about the SSO burgers and a fan of EMU double-decker burger, Mr. Michael collected hundreds of them somehow and went to the head office of the Melbourne SSO Burgers in order to redeem the car. So the thing was like when he reached the head office, one of the employees said that the vouchers were printed incorrectly. As a result, some of the vouchers are void. Whereas there was one customer who got one of the cars, and somehow when he went back to the place, he heard an announcement on radio that the promotion has been ended and no longer the SSO Burgers are providing the cars. So, like deliberately, he took the coupons, scratched them, and he found that he won the golden car. And as a result, he unheard or thinking that he did not get any official hearing from the SSO Burgers, he went to the head office again and claimed and sued them for not giving them the car or as per the contract. So the issue in the part A of the contract law is that the main issue is to determine the legal rights of Mickey and Brit, whether they will receive the Master CX from SSO Burgers or not. So the application of the rule will be further discussed by one of my group members. Thank you.
Hello everyone, my name is Gaurang Patel and my student ID is HIG3014. As my fellow group member will discuss about the issue, and now we would like to talk about the rules by which one we can go into certain conclusion of this case. The rule number 1 is an invitation to treat is not an offer. For instance, the case of AGC Advanced Limited versus McWhitner 1997 1 DLR 9454. The main issue is to consider the removal of the reservation is an auction as an offer. The second number rules is it can be an unilateral contract which can be promised to an individual against his performance, such as the Addington versus Addington 1952 1 KB 290, where the father promised to give his mortgage to his daughter and son-in-law. It was an unilateral contract where the couple repaid the mortgage amount and gained the possession of the house. So these are the rules for this case. And in the last, as seen in this case of the Delivius for Milbank Nominees Limited 1974 III ER 557, person making the unilateral contract cannot be revoked while the other person has stated his working. So these are the rules for this for our case and issues. Now my fellow group member would like to discuss ahead. Thanks.
Hello, my name is Yagnesh Patel, student ID AZZ3428. In this case, SSO Burger has stated that if customer gets 50 coins, they are entitled to get golden scratch coupon, and if they will receive a Mazda CX-9. So before the company revoked the offer, Mikey had already collected 50 coins. So company is now not able to revoke the offer as the act of performance has already started. In our case, now I would like to conclude that the promotion offer of SSO Burger is just a unilateral contract, and it was just a publicity stunt. As per peer law, offer can't be revoked due to act of performance, which has already been started in the case of Mikey and Brett. Thank you.
Hi everyone, my name is Mehresh and my student ID is EAI3015. I'm here to give you the presentation of business and corporate law of the topic according to the diligence and occur. We have the case study of Mr. Mercedes and Felix here, and coming to the issue is linked to the determination of breach of the general law of occur and diligence. That's what the topic is by Mercedes as a director. As coming to the rule, as stated in the provision of section 180, that is the act of diligence and occur. a corporate, as a managing director, the Mercedes have done the wrong thing without consideration the act of diligence and occur. The issue was like the Felix, as a corporate director, has taken the decision of buying the warehouses, but he was told that he should not make any delay in the decision making process. On that reason, the Mercedes have done the decision without taking act of diligence and occur into consideration. And this is what the application is. And coming to the conclusion, it can be stated that Mercedes did not comply with the duty of diligence and occur, and she had violated the provision of the section 180 of the Corporate Act. And coming to the second issue, to determine the availability of protection of section 180, which is the sub-clause of Corporate Act 180, which is act of diligence and occur, continuation to that rule. The provision of section 180 sub-clause of the Corporation Act 2001 provides the concept of business judgment rule. In this case, the decision was taken the decision should be taken according to the good circumstances of the company, which should be profitable to the company. That what Felix did. But when coming to the Mercedes, he did not take that into consideration, and then he took the decision application. The steps taken were for the betterment of the company. Felix's fixation was to improve the financial condition, which I told before. And coming to the conclusion, Mercedes can avail the defense of the provision mentioned in the section 180 of the Corporation Act. And in this case, Mercedes is liable for the case which he has done without considering the act of diligence and care. Thank you.
Hello friends, my name is Nishil Majumdar and my student ID is NPI3357. So today I want to present you for the business and corporate law assignment, and my part is the issue of the case, and the case is as my friend already presented you, the Mercedes-Benz case. So the issue in this case is which is presented in this case is directly Mercedes can be held liable for the violation of section 588 with the charities become insolvent, and in the rule is that as per 588G, the act of director lead to situation of being insolvent. If director is aware that the act lead to form insolvent situation, it's the violation of section 588G. And the application after reallocation, various situations lead to form outflows to the company. And the conclusion, it can be concluded that if Joytronics become insolvent, Mercedes would be directly liable for such action. And the second part is like issue again. Second is in this section it will be focusing on the factor of liability of Greg in terms of care of diligence and insolvent trading. As a rule for this case is as per the section 180, director abide by the provision of care and diligence. Director must take step to make the organization risk free, and the rule is okay. And the application applying the above rules in the present situation, it can be stated that the Greg did not perform his duty and care and diligence to evaluate the decision which is taken from the end of the Felix in the purchase of the warehouse. Although it can be stated that Greg is not executive director of the company, and he has to work with the care. He has to work with the care and diligence. So the conclusion with that one is conclusion in the end, it can be stated that the Greg as a director has directly violated the section 180 and 588G of the Corporation Act, as he is not a director of the company, as I already told you. And there are some references there, Davidson and all these things, Norris, and that's it. Thank you.